This conference will now be recorded.
Welcome, everybody. We are going to be talking about Chapter 2 in this lecture session. This is going to cover medical, legal, and ethical issues. Now, I'm not going to go through any lecture and pinpoint bolded items and basically read the book to you. I prefer a different style of lecturing, and this is one of the styles that I choose to do. So instead of doing that, I have a bunch of different scenarios that I've outlined, and we're going to talk about some of the different medical, legal, and ethical issues associated with each scenario. So this is our first scenario. You're dispatched to a nursing home in which an 87-year-old male patient began choking on a piece of steak at dinner. Patient is unresponsive, not breathing, unknown if he has a pulse. Under protocols from the nursing home, they are unable to touch the patient at this time. Patient has a valid DNR. So with this, the big question is, do we act? Do we do anything? Because we have a patient that is pulseless and apneic or dead basically at this point. So do we do our CPR and do we do life-saving measures, or do we leave him be because he does have that valid DNR? Do not resuscitate order is going to specifically state that in the event that I go into cardiac arrest, that I don't want to be touched at this time. Now we're kind of into a gray area, and we're going to talk about DNRs a little bit in length here. DNRs is one of those really goofy areas of emergency medical services. In order to have a valid DNR, it's got to be present with the patient, it's got to be signed, and each state statute is going to be a little bit different as far as how they treat DNRs. Now, Minnesota is in talks, and they might have just upgraded this, that it's got to be renewed on a yearly basis or a bi-yearly basis. So again, we should know our state statutes as it reflects on those DNRs to make sure that that DNR is still valid. Now, with a lot of DNRs, it will state that if there is a reversible cause of why this patient went into cardiac arrest, then we can go ahead and treat that reversible cause. Now, in this scenario, that reversible cause would be the fact that he is choking. So you can perform the Heimlich maneuver on this individual or perform chest compressions on him in order to get that object out. Now, with any of these issues, we're going to talk about documentation later on, but it's making decisions and then following through with those decisions and then documenting them properly. As EMS providers, we always have to act with a good conscience and then think about all those ethical things that we have to abide by. Now, one of those things is being patient advocates. So what or how would that patient want to be treated at any given time? Now, if we were to arrive on this scene and the nursing home facility was not able to actually obtain or show that DNR, then we have to treat that as a DNR is not valid. And so we would go ahead and start performing CPR or any other type of interventions. Now with us, we are protected under our medical director, which we talked about in Chapter 1, and then we also have liability insurance through our different organizations. But for us who are acting as volunteers, we are also protected under the Good Samaritan law. So the Good Samaritan law basically says if you act within your scope of practice, which you would do as an EMT, then you're going to be covered if you are not being compensated as an EMT. So again, if you're a volunteer, you're not paid for your service, you are covered under that Good Samaritan. If you are being compensated for your service, then you would have liability insurance through the organization that you are working for. So if we look down on the bottom left, that is what a DNR looks like. On the bottom right, this is a DNR bracelet. Now, again, I mentioned before that the states have different statutes in reflection of their DNRs. State of Wisconsin says that you can have a DNR bracelet, and that counts as their DNR. State of Minnesota does not recognize the bracelet at all. You need to have that paper form. So you're dispatched for an 89-year-old male patient not breathing. Upon scene arrival, patient is noted not breathing, no pulse. Patient's wife's on scene stated that she has a DNR somewhere in the house, but is unable to find it at this time. Asks you to leave her husband in peace. You grant her request, ask for law enforcement. Upon arrival of PD, you cleared the scene and return back in service. Now, we already touched on this. Remember that DNR has got to be with the patient in order for it to be treated as a valid DNR. Now, a lot of individuals, they'll take that DNR and they'll put it in a safe deposit box or a safe within their house, and then it's not easily obtained in an emergency. So if you have any family members, or if you're out in the community, or maybe even you go on a lift assist, this would be a great time to educate those individuals, keep it on their refrigerator or keep it close by so that they can access it if something were to occur. So next, you are dispatched at the Holiday gas station for a 16-year-old female patient who has taken a bunch of pills. 911 call was made by her boyfriend. Upon scene arrival, patient denies taking any pills at all. Boyfriend's on scene stated that he did not actually witness her take any, but thought she did. Patient's prescribed Ativan for panic attacks, but her pill bottle is missing. Parents cannot be reached. So within this scenario, we're going to touch on a couple of different legal and medical aspects. First, in order for a patient to be able to refuse medical care, they have to be an adult, so 18 years of age or older, or be declared emancipated minor. They also have to be sane and sober, so they have to be alert and oriented. So what you can do is ask them, do you know what day of the week it is? Do you know what month it is? Who's the president? What's your address? Ask them a couple of generic questions like that in order to determine that they're not in a confused state at all. And then they also can't have any mind-altering substances in their system that would negatively impact how they decide on whether they want medical care or not. So just from this scenario, and we're thinking of all those different components, this patient does not have the right to refuse at this time because she is under the age of 18. Now, her parents can refuse medical care for her, but at this time, the parents cannot be reached. So with our scope of practice, with our duty to act, we have to go ahead and take that patient and transport them to the hospital. Now, as EMS providers, we always have that duty to act, whether we're volunteer or professional service. Now, if we're volunteer, we don't have to go on every single call every time that pager goes out, but somebody within that organization should. That duty to act gets initiated right when those tones go out. And we're going to talk about negligence a little bit later. Now, if we were to reverse this and say that this patient is 19 years old, does she have the right to refuse? Well, another thing that patients can't do as far as refusal goes is if they pose a threat to themselves or others. So if the patient admits to being suicidal, if she does have a plan about taking her own life, then she technically loses that right to refuse. And this is where law enforcement needs to be heavily involved, because law enforcement will then put a hold on her, and then you can go ahead and take her in. So the next one, you're dispatched to a 56-year-old female patient with difficulty breathing. Upon scene arrival, you find the patient sitting in a chair with some shortness of breath. Patient is a frequent flyer, and you had transported her to the hospital yesterday. You decide that the patient doesn't need to go to the hospital and tell her that. Patient still requests to be transported, but it's at the end of your shift and your give a damn is busted. You clear with the patient no need and return back in service. So what you did is a couple of different things. So first is we're going to talk about patient abandonment. So whenever you start rendering care to a patient, if they need continued assistance, you cannot leave that patient. So you arrive on scene, patient's having difficulty breathing, you start treating that patient. You can't leave that patient until Go Across Ambulance arrives or somebody with a higher level of care arrives and takes over that patient for you. Now, if you get there, you start rendering care and you leave prior to an ambulance getting there, that would be classified as patient abandonment. In this case, that's what we did. State of Minnesota, state of Wisconsin, if a patient calls 911 and they wish to be transported, we, acting within our scope of practice, have to transport that patient to the desired facility that that patient wants to go to. Another thing that we can correlate this scenario into is negligence. So a good thing to read up on, again, we need a couple of different components in order to prove negligence. First, duty to act. So in this scenario, we did have a duty to act. We were working for an EMS organization and we got paged out to somebody. Now you breached that duty. So we breach that duty because we have to abide by the scope of practice, which states patient wants to go to the hospital, wants to be treated, then we have to do that. So we broke that duty. There's also got to be negative effects and then causation of all of those four components. So if this patient was having, let's say, an asthma attack and they ended up dying because of that asthma attack, well, we had a duty to act and we didn't respond well to that duty. We breached that duty. There was negative consequences behind it. The patient died and there was causation. The patient may not have died if we treated them within our scope of practice and actually treated that difficulty breathing and transported that patient to the hospital. Next, you're dispatched in Superior for a cardiac arrest. You are 1 week away from getting your paramedic certification. Paramedics on scene are having difficulty intubating the patient. You successfully intubate, receive a return of spontaneous circulation, and transport the patient. Return of spontaneous circulation is that patient began having a heartbeat and breathing on their own. Now with this scenario, what we did is we acted outside of our scope of practice. So we have two scopes of practice that we have to abide by: the states and whatever organization that we work for. So for many of you, you guys already have your emergency medical responder licenses with the state of Minnesota. So you're going to be going through this EMT course, learning advanced skills that only your EMTs can do on that organization or in that service. So you can't start performing those skills until you successfully hold an EMT license, because that is your license to practice. Now, just because you know this skill doesn't mean that you can perform it, because again, we're acting outside of our scope of practice. Now, this holds true too. I am licensed in the state of Minnesota and the state of Wisconsin as a paramedic. Now, I work for Hermantown Fire Department. I work for the City of Superior Fire Department. Both of those organizations are classified as EMT basic level services. So just because I'm on scene, I'm a paramedic, I can't technically perform paramedic level skills because I am acting outside of the scope of practice with my specific organization that I'm working under. Because I am working under my medical director states that I can only perform X, Y, and Z skills, so I have to abide by that or else I'm acting outside of my scope of practice. Next, you're dispatched to 1901 New York Avenue for a female with abdominal pain. You approach North 28th Street, proceed through a red light. An elderly female pulls out in front of you and you hit her driver's side flush going about 55 miles an hour. Driver is dead upon assessment. Now, this is one major reason why EMTs, paramedics, firefighters lose their licenses and lose their jobs, because they drive dangerously. Now, we have a lot of different warning devices on our rigs in order to get from point A to point B a little bit faster, but we still have to abide technically by all of the laws and regulations for driving. Now, we are granted some permissions as far as exceeding the speed limit a little bit, proceeding through a red light once we have come to a complete stop and all drivers have yielded to us. Same thing with stop signs. What we need to do is drive with what's called due regard. So we're always driving with due regard to everybody's safety around us. Now, when we are driving with lights and sirens, if I'm going 55 miles an hour or 45 miles an hour, I'm not really saving that much time. So speed really kills in these situations. So drive with due regard, drive safely. When you do have your lights on, make sure that you have your sirens on as well. When you come to a stop sign in a red light, make sure that you come to a complete stop before entering that intersection. Make sure that you make eye contact with every individual at that intersection to make sure that you are getting yielded by those drivers in order to proceed through that intersection. Be very cognizant about following another emergency vehicle. So if you're behind an ambulance or behind another fire truck, oftentimes people will pull over to the right and let you go by, which they have to do in the state of Minnesota and Wisconsin. However, most of the time they're not going to be thinking that there's a second emergency vehicle behind that first initial one. So that first ambulance will pull away from that driver, and then that driver will go ahead and pull up back out into the roadway. And that's where we see a lot of accidents as well. So you can be held liable for accidents like this. You know, in this scenario, this patient would probably be taken to court and then get a charge of vehicular manslaughter. Next, you're dispatched for a 6-year-old male patient who fell down a flight of stairs. Upon scene arrival, you find the patient sitting on the couch with his head in his hands. Patient is not answering any questions, but just continues to say, "I'm sorry." Patient has multiple bruises on his body that are both new and old. Patient's father is on scene. He's very standoffish, not giving a great deal of information besides that the boy fell down the stairs and is very clumsy. Now with this, I mentioned this earlier, we are all patient advocates. So we are an advocate for this patient. Sometimes patients can't get the help that they need because it's out of their control at this point. We are also classified as what's called mandatory reporters. So mandatory reporter, we have to report any type of abuse that is domestic assault, child abuse, and also elderly abuse. We need to report that to law enforcement officials. So for him, being a 6-year-old male patient, there's a couple of different scene dynamics that we got to be diving into. First, when we're doing a patient assessment, when the abuser is on scene and within earshot, we're probably not going to get very good information out of that patient. Same side of the spectrum, it's going to be very difficult in order to get that father away from that child in order to gain that access to do a good patient assessment and get good patient history. So trying to figure out how to separate that father from the child so that we can do a patient assessment and be very cognizant of your patient as well. He's a 6-year-old child. He's being abused by his father. So you got to be very good at doing a good patient assessment with them. Again, this is classified as our mandatory reporter because this is a child abuse situation. Next, you're dispatched to a 68-year-old male patient who cannot care for themselves. Call was made by a family member. Upon scene arrival, you find the patient in poor but livable conditions. Patient has cancer, DNR, and is on hospice care. Patient does not have any complaints but is weak and has an increased level of breathing. You deem it necessary for that patient to go to the hospital and force him onto the stretcher and take him in. Now, what we did here would be classified as kidnapping and assault. The patient does have the right to refuse at this time. They're alert and oriented. I mean, they have poor livable conditions, but again, they are livable conditions. Patient was able to answer all of your questions, but you forced him beyond his will and took him to the hospital. So you laid your hands on him, which would be assault and or battery. The state of Minnesota doesn't actually recognize battery, they only recognize assault, but some states will say battery is the unlawful touching, assault most oftentimes is more verbal in nature. And then kidnapping, you took somebody out of their possession and then took them to a different place, which would be classified as kidnapping at that point. So with a scenario like this, make sure that we're getting everybody involved, law enforcement, and then also get medical direction involved too. If you really think that this individual needs to go to the hospital, then try and coax them into going. If they absolutely refuse, this is where we want to get a refusal document signed. When we have a refusal document signed, we also want to state to the patient a couple of different things. One, make sure that you call back 911 if anything changes. And two, you have to give them the ramifications if they don't receive medical attention. So try and use the words dead, dying, or dead. If you don't go into the hospital and get checked out and you're having a breathing issue, then you could potentially die from this. So make sure that they understand the risks associated with not going into the hospital. You are dispatched for a one-vehicle motor accident with airbag deployment. Upon scene arrival, you find a 16-year-old female patient with a head laceration, no other injuries. Her 9-month-old daughter is in the car seat in the back of the car with no apparent injuries. 16-year-old female is complaining of head pain and may need a couple of stitches. Patient is refusing medical care for herself and for her daughter at this time. Now this throws a giant gray area into our scenario because we had talked earlier that if you're under the age of 18, then you don't have the right to refuse. However, now we have a 9-month-old daughter. Can this 16-year-old female actually refuse for her 9-month-old daughter, but not be able to refuse for herself? This all correlates to what your state statutes say and whether this patient is emancipated or not. So first, let's look at the 9-month-old daughter. This 16-year-old mother, if she does have custody and caring for that daughter, does have the right to refuse for the daughter. Now, in some states, this 16-year-old female cannot refuse for herself. Other states, because she is either pregnant or has given birth and she is caring for that child, that automatically makes her an adult. Other states, they still have to abide by the emancipation process where they actually have to go into court and get recognized and get the stamp of approval to become an emancipated minor. So again, it's that gray area, and that's where I love getting law enforcement involved in something like this. So we went through a lot of different terms in a scenario base. Again, make sure that you are reading through your chapters because I'm not going to cover every single thing in those chapters. But that concludes chapter 2. Thanks, everybody.